Christianity should continue to claim reservation benefits. Now, the centre has written to the KG Balakrishnan committee, which is headed by the former CGI, saying that once converted, Dalits cannot avail these reservation benefits. Now, if the argument from Muslim and Christian groups has been that Dalits convert to other religions because they want to escape the caste system in Hinduism, if that is the case, then why avail the benefits of reservation? On the other hand, what these groups argue is that just because they have converted to another religion doesn't negate years or even centuries of oppression, social oppression that they have faced at the hands of upper caste. But first, the story of the day.
हाय नरेंद्र मोदी जी, आपकी मोहब्बत उन बैकवर्ड मुसलमानों से, आप किस बुनियाद पर मुसलमान को क्रिश्चियन को एक्सक्लूड कर रहे हैं? वो तो राइट टू इक्वालिटी का खुला वायलेशन है.
दिस इज द रियल भारत तोड़ो ऑफ द बीजेपी एंड द आरएसएस.
All right, let me go across to our guest, R.P. Singh, spokesperson of the BJP, joining us. Swati Malik, spokesperson of the Congress Party. Kapil Sankla is a senior lawyer in the Supreme Court. Muhammad Asif Hussain Suhail is a political analyst. R.P. Singh Saab, you've heard from Jairam Ramesh and other Congress spokespersons as well. Not just the Congress, but both Muslim and Christian groups are saying that just because they convert, Dalits convert to Christianity or to Islam, doesn't negate or doesn't take away from centuries of oppression. They should continue to receive the benefits of reservation. Your response?
Dimension to this. One is that as per the law, as per the constitution, there is no reason to give the reservation to Christians and Muslims. It's only for, as per the constitution, for the Hindu, Sikh, both.
R.P. Saab, there is a problem with your audio. Let's try and fix that. Just give me a second. I'll try and ask our audio team to fix that audio, and then I'll come back to you. But Swati Malik, the question that's being posed by the BJP is, if the Dalits are converting to Christianity or to Islam ostensibly to escape subjugation under the caste system, then why should they avail the benefits of that very same caste system?
Saga, this is the most absurd argument which has been put forth by the centre. The reservation is for those who have been suppressed because of caste, because of religion, because of caste. And we all know that even Muslims, whether Dalits within Muslims or if they've converted to Christianity as well, they too have faced casteism, they too have faced suppression within that community, because of the community, within that religion. So it's rather absurd when the BJP says that just because they are Muslims and Christians, that's why they don't have any caste system within the religions. That is why they've not suffered anything. We all know the practical aspect.
One second. Swati, it's not a question of whether they've suffered or not. That is a separate debate altogether. The idea of conversion, as many groups, not just political parties, but even religious groups have said, the reason why many Dalits want to convert to Islam or to Christianity is to escape the burdens of the caste system. If the act of conversion is being justified by escaping the burdens of the caste system, then why should you avail benefits that accrue by way of reservation? You have escaped the burdens of the caste system.
But have they escaped the burdens of suppression? Have they? That is the question. Forget what the religious leaders say. Even when they say that within Muslims there is no caste system, we all know there is a caste system even within Muslims.
Okay.
Right? So they all have suffered. It's rather absurd to say that they've escaped it just because they have converted.
Okay, let me ask R.P. Singh. He's back on the conversation. So just because Dalits convert to Christianity or Islam doesn't mean they escape the caste system. That's the argument by Swati Malik. Whether it is Pasmanda Muslims and Bora Muslims are not treated the same way, Latin Catholics and Roman Catholics are not treated the same way. So that is the argument that Swati Malik is putting, that there is caste system in Islam and Christianity also. So why should they not avail the benefits of reservation?
But what does the Constitution say about that? I was coming to that point only.
Sure.
The Constitution defines it differently. So we are abiding by what Constitution says. And also, otherwise also, when they convert to any other religion, which is Christian or Muslim, Islam, they get benefit of the minority, as minority there in that part. So there are some advantages and disadvantages when you shift from one religion to other religion, and they shift to that to Islam or Christianity, keeping this in mind, and then they are shifting only because they feel that they are not being treated equally here. That's why they are shifting, or they are converting to Islam or to Christianity. So
no, RP Singh Saab, the question is, for example, you know, even in Sikhism, and you're a Sikh, there are Jat Sikhs, there are Dalit Sikhs. Tomorrow, if the centre were to say that Dalit Sikhs cannot avail reservation or avail benefits accruing from their status as Dalits, would that be acceptable?
Well, those who are converting to Christian, they don't get that advantage now. There's the issue in Punjab also. Those who are converting to this big number which is converting to Christianity, they don't get all that advantage which the normal Sikhs get, because Sikhs are classified as the broader part of the Hindu definition in the law, as section 25(2)(b), if I'm right. So it categorically says that the Sikhs, the Jainis, the Buddhists are part of the wider Hindu definition.
Okay. Swati Malik, again, you know, I'm coming back to the moot point in this argument that time and time again it has been said that the reason why they want to convert is to escape from the caste system. If they're doing that to escape from the caste system, then they shouldn't be availing benefits accruing from reservation.
Zaka, this question has been considered by various commissions. Various reports have been filed with the government. Various reports, not just one or two. There are 6 to 7 reports which have been filed, which have considered all these arguments, all these aspects, and they have come to a conclusion that Dalit Christians and Muslims should not be excluded just because of their conversion. So while we debate here, let me also, like I said, there's 6 to 7 reports which have been filed which support this, that they should be included and not excluded just because of conversion.
Okay, let me ask Kapil Sangla on that point of the commissions that have looked into this matter before, whether it's a Sacha committee, whether it's the Deshpande committee report, all of them, at least in conclusion, seem to have found merit in the argument that Dalits, even if they convert to Christianity or Islam, should continue to get the benefits of reservation, because an act of conversion does not negate years or centuries of social oppression.
Zaka, some of them, not all of them, that is one. Secondly, we have to look at the Constitution of India and also what the Honorable Supreme Court has said, and we limit ourselves to that. I will not like to lock horns with Swati on this, but I will just see what the law is. You see, as far as the Scheduled Caste order, which is the Constitution is concerned, para 3 says that no person who professes a religion different from Hindu, Sikh or Buddhist religion shall be deemed to be a member of a Scheduled Caste. Now, the Nehru government in 1950s also limited the definition of Scheduled Caste, which was subsequently extended, but this is what the law as on date is. Now, this Constitution Scheduled Caste order 1950 was based on hard facts and data, and there was historical data to show that there was no backwardness or oppression was faced by members of Christian or Islamic community or society. In fact, one of the reasons, and I am quoting this, and one of the reasons for which people from Scheduled Castes have been converting to religions like Islam or Christianity is so that they can come out of the oppressive system of untouchability, which is not prevalent at all in Christianity or Islam. So this is what it is. You're talking about oppression of birth. It doesn't matter what you do. And this is, I think this was an argument that I put before you when it came to the EWS case as well. I said the thing is that a rich man can be poor tomorrow, or a poor man can be rich tomorrow. But a scheduled caste will always be a scheduled caste, be it he may be a lawyer, doctor, or whatever profession. He might be a scientist. But the mechanism is that he suffers the surname and he suffers the liability of the surname. But an Ambedkar can tomorrow be an Andrew or an Abdullah and, you know, break away from those shackles.
No,
but,
that is the point that they are asking.
But an Ambedkar will always remain Ambedkar.
An Ambedkar becoming an
right?
Andrew or an Abdullah does not negate 200, 300, 400 years of oppression. Does it?
Yeah, but you're actually talking about now. See, what happens now is nobody asks him what is your caste. And when you're talking about the liability of 200, 300 years of oppression, he has broken that karmic chain. He has broken those shackles because he is no longer associated by his caste.
Okay.
And therefore, you know, just to say this, there are two very important things. One, the ruling of the Honorable Supreme Court in 2015, which said, once such a person ceases to be a Hindu and becomes a Christian, the social and economic disabilities arising because of Hindu religion cease, and hence it is no longer necessary to give him the protection, and for this reason he's deemed not to belong to a scheduled caste. This is a 2015 ruling of the Honorable Supreme Court.
Let me ask
end it by what
Mohammed.
3 days back Justice Bhat said. Justice Bhat said this very, very quickly. He said this. He said that quota is a compensatory mechanism. It is not a free pass. What is being sought today is free pass because of what the forefathers were and not what you are today.
Okay.
The compensatory mechanism is what you are born to today and what you shall remain always.
As per the Constitution, this is from 1953, the SC status only applies to people who are Hindu or Sikh or Buddhist. The Sikh amendment, I think, got added in 1956. And the Buddhist amendment got added in 1990. This is the position of the Constitution as it exists right now, Muhammad Asif Hussain Sohail. Why are you asking for a change in that? I mean, why should the Constitution be changed to accommodate groups of individuals who have left their religion of their own free will? Nobody forced them to convert.
Yeah, see, it's not about the conversion. Yeah, the social status has not been changed as on date. Like, you know, when it comes to why only with the Christians and the Muslims, why not with the Sikhs, Jain and Hindu, other people have been included. See, now the government is only threatening the common man not to get converted. It's all about the conversion. Just to stop that, with their free will, they are telling the social status has to, you know, it will change. Let them, you know, decide whether whatever the religion they want to be. Like, but you know, what they have gone through, it's not going to change. That cannot be accommodated.
No,
for
but
a certain time, what I feel, you know, that the status has
part
to
of
be
the reason why they are converting. No, one second. If part of the reason why they are converting is not for change of social status.
That's what I'm saying.
If it is not for change of social status, then why are they converting?
That's what, see, for the generation they have been in a on the particular one caste, you know. When they are moving on to another religion or to another caste, you know, it will take time to get settled. Let the government fix up some kind of boundaries. It's only why it's been stopped to the Muslims and Christians. It has to be equally. See, here also there is a discrimination going on. Status is not the luxury. You know about that. I see status is not all about the luxuries. It's about the basic necessity, you know, what they have not been got in all that years and from the past, from the forefathers.
So let me ask RP Singh that. I mean,
set for that.
The Christian and Muslim groups can also argue, as Muhammad Asif is arguing, that you have caste system in Islam, you have caste system in Christianity, you certainly have caste system in Sikhism also. Why should the same not be extended to Dalit Sikhs?
Zaka, we have to go back to time and probably change or tinker the constitution which was laid by no less than Ambedkar ji and other luminaries, where they as I said, they classified, they clubbed the Sikh, Jain, Buddhist, Hindus together. It was not us, they clubbed it together because they are the religion of Indian origin. There are two religions which are not of Indian origin, and that's why they talk of equality in the system, whereas we accept there has been disequality and there has been a caste system in our form of religion, but in their religion they never accepted that. Although because they have been Indianized, that's why probably they are doing that. But the truth came out when the earlier panelists said that this will to deter the conversion. And let me admit to you, in Punjab, there is a huge conversion which is happening, a Christian conversion which is happening. To my knowledge, one of the pastor, Ankur, says that he have converted almost 40%, but they still continue in religion of Sikhism. They don't declare themselves as Christians, but they go to church, they take like to enjoy all that whatever benefits of allurement or conversion is there in Punjab. But they are not able to take benefit of being Christian convert.
Okay.
So there's a thin line there also, and then there's a dichotomy there which needs to be tackled. But yes, religion of Indian ethnicity has been dealt differently and in different fashion.
So Adil Malik, the position that the Constitution has taken, whether it is in 53 extending it to 6 or whether it's in 1990 extending one second, extending it to Buddhists, that is not something that is the making of the BJP. The BJP did not introduce this in 53 or in 1990. They were not in power. So why are you then making this a political issue?
6, if it can be changed to include 6, and if 1990 it can be changed to include Buddhists, then why not include the Muslims and Christians now? is all we are saying. We are not saying that, it is only please note at the conduct of the BJP here. They believe in this. They believe in this Bharat Todo, is as we are saying, right? They are trying here to further Todo.
What's there about Todo about it? You want to Todo Bharat by doing so.
Let me, sir, I didn't interrupt you. You will also please extend the same courtesy. All I'm saying is, this is the Bharat Todo against which the Congress is doing the Bharat Jodo Yatra today. This is the mentality. This is the intent behind this. And look at the affidavit.
No, how is this Bharat Todo? I just want to know. I mean, it's a political debate. It's a legal debate. How is it Bharat Todo?
Absolutely, it is Bharat Todo because within Dalits also they're trying to divide the Dalits on the basis of their Hindus and Muslims and Sikhs and Christians out there. Please understand, what is the affidavit that the center has filed? What is the reason given in the affidavit? They said these religions are of foreign origin. This is the reason given. Or the second reason given is non-existence of documented evidence. Now, when they say non-existence of documented evidence, this is where I bring in those committee reports, whether there is enough evidence or not. That was considered by those commissions. Now, whether it is foreign origin, foreign origin religion,
I just want to clarify that we have got word from top legal officers in the government that there will be a new affidavit that they will submit, or a new filing that they will submit before this commission, specifically on this issue of foreign origin. But anyway, R.P. Singh respond, and then I'll go to Kapil Sankla after that. Yeah, R.P. Singh.
Very small thing. I mean, they're talking about Bharat Todo. I mean, when you got the constitution made in 1953, all those who were part of the making of the constitution, wo Bharat tod rahe the kya? They were dividing the country at that time. I mean, it's such silly argument they're giving. And also, what they did in 1990, why couldn't have they extended the same to other religions also? But they didn't do so. So we are saying that they were tab ye Bharat tod rahe the kya? They're dividing the country at that time. But issue is again, there are religion of Indian origin and there are religion which are of not Indian origin.
Okay.
And then religion of not Indian origins don't believe in caste system. They lure people with saying this, that we are taking you out of the caste system. And once you say that and lure them by saying that we are taking you out of the caste system, then why you want reservation for them?
No, but Kapil Sankla, the argument again being raised by opposition is that you have just amended the constitution to include a new quota called EWS. Now, what if a converted Dalit who converts either to Islam or to Christianity happens to come in that category of under 8 lakh rupees per annum? The conversion benefit may not be there, but he or she can avail of EWS quota then. Kapil Sankla.
So good for him. What is the difficulty? The second thing is that he also gets the benefit of minority institutes, where the Honorable Supreme Court has said the government will have no say. And we see these minority institutes and also companies that are run by minorities for the benefit of minorities. They have that benefit as well. So I really don't know what the argument is. And as far as what
minority
is being
institutes,
said,
one second, I think that's a good point. I'll ask that. But Kapil, minority institutes are not government run. Minority institutes are private institutions. This is about government run institutions, whether it's for education or for jobs.
Where the government cannot have a say. Please
Yes.
understand this. If a minority institute is run for the benefit of minorities and the government cannot have a say in that, that is absolutely for the benefit of minorities. And this is also a minority argument that this is for the benefit of minorities. We will not have any quota system there. So nothing works there as far as SC, ST, OBC, etc. is concerned. And this is also what the Supreme Court also stated as far as EW is concerned. In fact, this was the concern with the other panelists when I was on your show, I think a couple of days back. And as far as the other thing is concerned, what Swati was saying, let me point out another judgment in deference to what she said. This is CPIL versus Union of India, where the central government has told the Supreme Court there is no authentic data to suggest that Dalit Christians or Muslims have suffered the same oppressive environment like Dalit Hindus and hence cannot claim benefit of such scheduled caste as entitled to Hindus. And the affidavit says this further, that extending the reservation benefit to Buddhists while denying it to Muslims and Christians, arguing that not only the nature of conversion is different, but the original caste of those converting to Buddhism can also be ascertained. The affidavit said, the SCs embraced Buddhism voluntarily at the core of Dr. Ambedkar in 1956 on account of some innate socio-political imperative.
Okay.
The original caste community of such converts can easily be determined. This cannot be said in respect of Christians and Muslims who might have converted on account of other factors, since the process of such conversion has taken place over the centuries.
Okay, let me ask Muhammad Asif Hussain, the point that Kapil made about, I mean, you want to avail benefits of reservation, there are always minority institutions, there are Muslim-run minority institutions, there are Christian-run minority institutions. You can always go to minority institutions.
That's what, like I see, I've asked you the same thing again. Like, the Sikhs, Buddhists and others, they don't call them the Hindus, right? They call it comes from the Hinduism or what?
No, but they do.
See, when they are getting converted, no. Who said that?
The gentleman prior there to just said that Sikhi comes. Jaka, can you please?
Yeah, Sikhism comes from Hinduism. Historically, no, but anyway, that's besides the point. Answer the question that I asked you. Minorities get to avail of minority reservation in minority-run institutions.
That's what. See,
no one else gets to make that in minority institutions.
See, that's what. It's instead of government providing the equal rights and equal opportunities and equal benefits to all, because they have failed. All this came on the SC status, minority status. Why it came? Because they are not been treated equally in every segment, in every field of they are seeing it. So for certain period, what I am saying, government should make a boundary on that, something where they can avail for the certain time. Then they can, when they have been converted to wherever the religion they came from, there they will get the benefits over. So all to sudden, if you stop something, what they have been getting over there, then it will find them difficulties.
I'll give the final word to RP Singh. I want to wrap up after this. No, I think there was the Mishra Commission report. One second, there was a Mishra Commission report, I think it was in 2004 or 5, where they said, the Commission's argument was, if you're going to take away Dalit reservations for Christians and Muslims, then you should do the same thing for scheduled tribes. Scheduled tribes also, there are Christian scheduled tribes, there are Muslim scheduled tribes, there are Hindu scheduled tribes, but there is no distinction of religion for ST reservation. ST reservation, they get irrespective of religion. The same argument should be extended to SCs also.
Zaka, I'll appreciate, let me turn the table other way around. Will any Christian or Islamic or Muslim institution give reservation to the Dalits or scheduled caste? Will they give reservations? No, they don't. I'm asking them. Aligarh University, will Aligarh University do so? No. Will Stephen College do so? No. They don't give reservation to the scheduled caste. They say no, we won't allow that to happen. So it's very basic that when they convert, scheduled caste convert, it means they are converting because they are being oppressed. Scheduled tribes don't get reservation because they were oppressed. They are backward because of other reasons. Here there is a oppression of the caste, of a social system. So that's why they get there. And conversion means that they are accepting that yes, they are equal now.
All right.
That's why in Punjab, I'm sorry, I'm quoting Punjab being a Sikh. That's why every convert in Punjab put Masih as a name, as a caste. They don't put other caste, whatever other caste they have. They only put just Masih as an add-on name.
All right. Okay, we've got to leave it at that. Thanks very much to RP Singh, Kapil Sankla, Mr. Hussain, and of course Swati Malik for joining us. What we're going to do now is to move on to a piece of breaking news that's coming in. The Enforcement Directorate has claimed in a remand note that all 34 people involved in the Delhi excise policy scam have changed their mobile phones multiple times. These 34 individuals have changed their phones 140 times. Just the cost of those phones alone amount to a little over 1.2 crore rupees. Let me go across to Ashish Mershi, who's joining us with more details on this. So this includes Manish Sisodia as well?
Yes, in fact, that is what the claim is, Zaka. It's absolutely flabbergasting, absolutely surprising, because all these 34 individuals who are being investigated by the Enforcement Directorate and the CBI into this scam all have changed their phones. So this is basically nothing else but deleting, or you can say, a killing of the evidence. That is what is visible as of now. So this is something really, really surprising. All these 34 individuals, including government servants, including liquor barons, including Manish Sisodia, everybody has changed their phone. And, these phones have been changed multiple times, not even once. So around 1.2 crore rupees, around 140 phones have been changed by these 34 individuals. So this is something absolutely stunning. This is something really, really surprising that has been claimed by the Enforcement Directorate in the remand note. Both the individuals who were arrested today, Binoy Babu as well as Sharath Reddy, they both have been remanded to 7 days custody. But this is something really surprising that the ED has claimed in the remand note.
Ashish, very quickly, the mere fact of the changing of phones does not necessarily establish complicity or otherwise.
No, it does not, but certainly, it's like killing of the evidence, because what happens is, once you delete the, say, WhatsApp messages or Telegram messages or any other messages, and you change the phone, so you can't get it back, even despite making effort from the CFSL, if the CFSL also tries, they can't get it back. So basically, it's like, you can't get all the messages or any data which is inside the phone, in the previous phone. If the phone gets changed, you can't get it. So that is why this is something like killing of the evidence, certainly.
Okay, we'll see how the story plays out in court and whether the court is subscribed one way or the other into buying this argument. We'll leave it at that. Thanks very much. The other big story, of course, happening in Hubballi, where the municipal corporation has granted permission now to the AIMIM for Tipu Jayanti celebrations at the Eidgah Maidan. This happened in Hubballi in Karnataka. The mayor granted the permission for observance celebrations despite strong objection coming in from the Hindu organizations as well as the Congress party. Meanwhile, the Shri Ram Sene leader Pramod Mutalik protested at the Eidgah Maidan today against Tipu Jayanti celebrations. Meanwhile, the Dharwad Municipal Corporation, those are twin cities, Hubballi and Dharwad, the mayor there has now granted permission to the Shri Ram Sene for Kanakadasa Jayanti, which starts tomorrow at 9 a.m. Harish now joining us live. Even when the Bangalore Eidgah Maidan matter was resolved by the Supreme Court, or at least a judgment was passed by the Supreme Court, that was thought to be the precedent, if you will, that in other Eidgah Maidans it will not be used for any kind of celebrations, whether it is Tipu Jayanti or Kanakadasa Jayanti. Does this now open a Pandora's box?
Yes, it definitely does. If you look at the argument by the Hubballi-Dharwad Municipal Corporation, it says that this is a corporation ground and it will be used as any other corporation ground, which means it will be given out for various events, whether it's religious or not. That's the decision of the Hubballi-Dharwad Municipal Corporation Mayor. And yesterday, remember, this decision came out and they decided to allow Tipu Jayanti celebration. Today, they've said that we'll allow Shri Ram Sene to celebrate Kanakadasa Jayanti tomorrow. There are two things here that stand out. One, perhaps many within the corporation believe that there's an ongoing case regarding this particular Eidgah Maidan, and this stance of the corporation makes their case much more stronger in the court to say that we are not in any way taking a partisan view. We are being equal to everyone. We want to treat this as a corporation ground and give it out to various people based on the bylaws and rules of the corporation. One. Second, if you look at it politically, many believe that the local corporation ruled by the BJP allowed this to happen, allowed Tipu Jayanti there, because one of the petitioners was a contender for a MIM ticket, and they believe that if these leaders from the MIM become stronger, then the Congress loses some core minority votes in Hubballi-Dharwad. So it will be win-win for both the BJP and the MIM there. So that's the political analysis coming out of Hubballi and Dharwad on why the BJP mayor there allowed Tipu Jayanti and has allowed Kanakadasa Jayanti tomorrow.
It is politically also interesting, isn't it, that a BJP-ruled municipal corporation, a BJP mayor allowing the MIM to celebrate Tipu Jayanti, which the BJP had been opposing tooth and nail over the last few months and years. We'll leave it at that. Thanks very much. In a moment, Griha will join you with the biggest exclusive.
There is a certain element that is saying when we have nothing to do with the government, when we don't take any aid from the government, then the government has no reason for any oversight.
There was no objection as long as the Lotus is formed under the Congress government. But it's a problem the moment the BJP has Lotus as its symbol and Lotus then stops being a national flower.
Remember what the Democrats had in 2018. It was 222. Will the Republicans get to 222? Will they get less than that, more than that? I think that is an interesting figure to watch out for.
Tamil Nadu, Telangana and in Kerala, the opposition that is coming from the governors is also political in nature. If the governor is constantly at loggerheads with the state government, then how will the state government function?
Hello and welcome. I'm Priya Atul Siddiqui. On Biggest Exclusive tonight, we talk about the decade-old gruesome rape and murder case that had sent shockwaves across the country. Predators moving on the streets looking for prey should be hanged till death. That was what the Delhi High Court had observed while upholding the 2014 trial court ruling of awarding capital punishment to the accused in the 2012 rape and murder of a 19-year-old in Delhi's Chawla area. The accused had then appealed to the Supreme Court of India in 2015. The case that was in limbo for the better part of a decade on Monday saw the accused walking scot-free. Yes, the Supreme Court of India pronounced its judgment in the case, and in what came as a shock to parents and the well-wishers of the victim, the apex court acquitted all three accused. Remember, this was a gruesome rape and murder where the victim was beaten with car tools, her body parts had cigarette burns and acid poured on her. Her mutilated body was found 3 days after her abduction. So despite the police claims of having solved the case with confessions from the accused and findings of investigation reinforced by DNA evidence, and the trial court and the High Court both having accepted it to award the death sentence, why this acquittal by the Supreme Court? This, even as the apex court agreed that if the accused involved in heinous crimes go unpunished or are acquitted, agony and frustration is caused to society and to the family members of the victim. Reason: the prosecution failed to prove the charges beyond reasonable doubt and that there were glaring lapses in the investigation. The Supreme Court further gave its informed reasoning, saying that courts should strictly decide cases on merits in accordance with law and should not be influenced by any kind of outside moral pressures. But what happens to the victim's family, who clearly is devastated and shocked because of this verdict? What about the justice that is due to them? So let's now first look at why the Supreme Court, the apex court of the country, let these men off. This is what we have found out through the observations that have been made by the court. Now, the court went on to say that unable to prove the evidence, identification and medical reports, all of this really claim about the glaring lapses. Also, prosecution failed to point out the guilt of the accused. Very, very important point again mentioned by the court. Lack of clear, cogent evidence and DNA profiling. Again, something very important mentioned by the court over there. Also, glaring lapses during trial of the matter. Time and again, this is what the apex court of the country had claimed. 10 out of the 49 witnesses were not cross-examined by the defense. Very, very important point that the court made. So clearly, here they're talking about the police investigation that was, so to speak, held by the trial court and later by the High Court, the Delhi High Court, but something that really claimed shoddy investigation that really was brought out by the apex court of the country. Now, the judgment by the Supreme Court goes on to find fault with the police investigation. However, the critique it offers on the judicial process and not being free from defects cannot be missed either. The trial court and the High Court, after all, did accept the findings of a bad investigation. The holes in the investigation pointed out by the Supreme Court judgment should have ideally been caught by the trial court itself. But let's look at what the trial court verdict really said. So, The kidnapped vehicle was in custody of the accused. That's point number one that was brought to light. Victim's hair strand was found on the car seat. Point number two. The other thing that was brought to light was DNA from the semen spots was similar to that of the accused who were in custody at the time. Body was recovered on disclosures by the accused. Remember, the accused number one was the one who led to where the body can be found. Accused wallet was found near the victim's body. That was a very important piece of evidence. Victim's blood spots were found on the vehicle tools. Another important piece of evidence that was brought in the court by the investigation authorities. Autopsy opined that victim was hit by a jack and spanner. Car tools were used to hit the victim. Car's broken bumper piece was found near the victim's body. That's how gruesome this entire tale of abduction and murder was. Victim's clothes were found at the accused's rented flat. So remember, after the rape, she was abducted and taken out of Delhi. Mixed male DNA profile found in the swab test. Hence, there were evidences of a gang rape. Mixed male DNA profile, like I mentioned, was something that was an important point of the investigation that the court chose to stand by, and hence awarding that death penalty. Now, we can go ahead and break all this down and look at the legal loopholes. But what does this mean for the family members of the victim, whose only hope was to seek justice for their daughter? I'm joined on the broadcast by Kiran's parents. बहुत शुक्रिया आपका हमारे साथ जुड़ने के लिए। मैं जानती हूँ कि बहुत मुश्किल समय है आप लोगों के लिए, लेकिन आगे क्या तय किया है आपने इस लड़ाई को जारी रखने के लिए? रिव्यू पिटिशन दायर करेंगे?
जी, अपील करेंगे और इसको ओपन करके जो है इसको दोबारा से इसमें जो है कि कार्रवाई होगी। ये मेरे साथ में जो हुआ है वो तो मैं भूल जाऊंगा, लेकिन आगे जो आने वाला जो समय है और जो डिसीजन हमारे सुप्रीम कोर्ट के जज ने दिया है वो एक बहुत भयंकर डिसीजन दिया है कि मतलब जिन मुलजिमों को फांसी का लोअर कोर्ट से है और हाई कोर्ट से डिक्लेयर हो चुका है, और सुप्रीम कोर्ट में जहाँ पर न्याय होता है वहाँ पर सुप्रीम कोर्ट के जज ने उनको बरी कर दिया है। मेरे को अफसोस हो रहा है कि आगे आने वाले समय को कैसा काटेंगे हिंदुस्तान की बेटी, माँ, बहन जो भी हैं, वो कोई कॉलेज जा रहे हैं, कोई स्कूल जा रहे हैं, कोई अपनी जॉब करने जा रहे हैं, टाइम बे टाइम आना जाना। जिस तरह से वो 3 मुलजिम थे, आज 3 हैं, वो कल 300 हो जाएंगे, 600 हो जाएंगे, क्योंकि उनको पता है कि हमें सुप्रीम कोर्ट से बाइज्जत बरी मिल गया है, जबकि हमको फांसी होनी थी।
जी मैम, आप एक माँ हैं, बहुत लोग जुड़े हैं आपके साथ इस लड़ाई में। यहाँ बात आज देश की हर बेटी की हो रही है, उसकी सुरक्षा की जा रही है। आप उन सभी को जो आपके गम में शामिल हैं, उनसे क्या कहना चाहेंगे?
अब तो कोर्ट ही जाने की क्या चूक हो रखी है। चूक होती तो मतलब लोअर कोर्ट में, हाई कोर्ट में कैसे डिसीजन आ गया कि फांसी दो इनको वहाँ भी तो कुछ चूक हो सकती थी। चलो लोग लोअर कोर्ट से फांसी दे दी, हाई कोर्ट में चूक हो सकती थी, तो वहाँ से भी कुछ मतलब फांसी का ही ऑर्डर था, लोअर कोर्ट से फांसी का ऑर्डर था, और सुप्रीम कोर्ट में आके ये एकदम से इन्होंने मतलब तब तक पलट दिया।
सरकार से भी कुछ अपील करना चाहेंगे आज आप?
सरकार से अपील हमारी ये की है कि मतलब इन दरिंदों को फांसी दिया जाए, और ये अन्याय है और आगे आने वाली पीढ़ी के साथ में ऐसा ना हो। और जिस तरह के सुप्रीम कोर्ट के जज ने मतलब जो है कि इन दरिंदों को बरी कर दिया है, तो बरी करने के बाद इनके हौसले बुलंद। ये लोअर कोर्ट में हमको धमकी देते थे जब ये तिहाड़ से पेशी पे लाए जाते, बिल्कुल वहाँ पे है जैसे अब हम पेरेंट्स हैं, आप हमारे साथ में सपोर्टर में आए हैं, तो उधर से आए तो हम आपको बाहर निकलने के बाद काटेंगे। ये क्या सीन है? 7 साल वो फाइल सुप्रीम कोर्ट में थी, डिसीजन आने, हाई कोर्ट का डिसीजन आने के बाद 7 साल में उस फाइल पे एलिगेशन नहीं लगा, और एक दिन में उसमें एलिगेशन पैदा हो गया। ऑर्डर फाइनल करने के बाद मुलजिम को बोल दिया तुम अपने रास्ता नापो, और मैं अपना रास्ता नाप रहा हूँ।
तो आप ये कह रहे हैं कि चूक जहां पे भी हुई है, आपको ऐसा लगता है कि पब्लिक प्रोसिक्यूटर के सही तरीके से केस ना प्रेजेंट करने की वजह से ये हुआ है? क्या आप ये कह रहे हैं?
हमारी सरकारी वकील को क्या वैल्यू रखेगा? हाँ, होता मेरा अपना वकील पर्सनल, तो वो धड़ धौंस पे वहाँ पे वो करता, बहस करता, जिरे करता। लेकिन एक तो लेडीज, ऊपर से सरकारी, जो सरकार ने दिया था वो हमें उसी पे चल रहे थे। और लोअर कोर्ट से हमें सरकारी वकील मिला हुआ था, लोअर कोर्ट से हाई कोर्ट से सुप्रीम कोर्ट तक। सुप्रीम कोर्ट में मुलजिम को सरकारी वकील दिए जा रहे हैं, क्यों? एक तो उन्होंने क्लेम कर रखा है, ऊपर से उनको सरकारी वकील दिया जा रहा है। मैंने जजों से पूछा भी था, अपने साइड के जो जज, अपने इनको सरकारी वकील क्यों? बोला जी इन्होंने अपील डाली है कि हमारे पास पैसा नहीं है, हमें वकील सरकारी दिया जाए, और उसी का बेनिफिट उठा गया जज।
जी, हम समझ सकते हैं, बहुत ही शॉकिंग वर्डिक्ट रहा है आपके लिए आज जो सुप्रीम कोर्ट से ऑब्वियसली सामने आया है। रिव्यू पिटिशन जो आप डालने की सोच रहे हैं, कुछ अपील करना चाहेंगे हमारे चैनल के जरिए?
कोर्ट से मैं यही कहना चाहूँगी कि एक बार हम अपील करेंगे तो कृपया उस पर थोड़ा ध्यान धरें, ताकि ऐसे मतलब ऐसे दरिद्र छूटे नहीं, क्योंकि कहीं पर भूल चूक हो जाती है, गलती हो जाती है, तो उस पर थोड़ा गौर करके, ताकि हमें भी इंसाफ मिले। 10-11 साल हो गए, तो एक माँ के लिए 11 साल के 11 दिन भी बहुत होते हैं। तो इसी कारण ये है कि हम बहुत दुखी हैं उस दिन से। तो पहले तो ये था कि चलो, हमने ये सोचा कि चलो फांसी नहीं तो उम्र कैद होगी, तो जज साहब ने तो बिल्कुल ऐसे कर दिया कि बिल्कुल उनको बरी कर दिया, जैसे उन्होंने कुछ कांड ही नहीं किया हो। अब चलो उन्होंने नहीं किया, माने किसने किया है फिर? या तो और मुजरिमों को ले आओ वहाँ पे कि इन्होंने कर रखा, तो हम मानेंगे कि चलो इन्होंने किया तो इनको छोड़ो। पर ये नहीं, जब सब चीज़ उनकी निशानदेही पे, और लड़की वहाँ से मिली, रास्ते खुद पुलिस को उन्होंने रास्ता बताया कि हम वहाँ से उधर रास्ते से वहाँ गए हैं।
जी, बहुत शुक्रिया हमारे साथ जुड़ने के लिए। द फैमिली मेंबर्स क्लियरली very gutted, as you can see from the appeal that they are making through this verdict that's come out of the Supreme Court. They are of course going to be filing a review petition. However, what happens to their faith in the judiciary is also the big question. Let me open the debate now on the show. We are asking, the Chhawla murder rape case, is this a clear case of justice having been denied to Kiran? That's the big question. Let me take this across to my other guests who are now joining us on the broadcast. Swapnil Kothari, who's an advocate, joins us. Also joining us is women rights activist Yogita Bayana and Charu Khanna, who's the former member of the NCW. Thank you so much for being a part of this discussion. I will start with you first, Swapnil. Do you think from what has happened in the course of everything that's come out of the Supreme Court, is this a case of Apex Court trying to school the lower courts, in this case the Delhi High Court and the trial court, and in doing so, justice has been denied to Kiran?
Griha, the schooling of the lower courts is a secondary aspect. The Supreme Court can always do that on its own, not through a case, but even otherwise through phone calls or through seminars or through several discussions that they seem to have with the lower courts off and on. So it's called the advisory jurisdiction of the Supreme Court in many ways, or the supervisory jurisdiction to be so precise. The advisory is to advise the president, but the supervisory is to supervise the lower courts. Now, as far as the denial of the justice is concerned, obviously, I believe that being a victim's family, if I was there, I would definitely be perturbed and shocked by this event, especially by this judgment, especially when the two courts, the trial court and the high court, have confirmed the death penalty. So here the acquittal itself is a big blow, a body blow to the victim's family.
Yeah.
But having said that, if one looks within the parameters of the three acts which govern the criminal jurisprudence, which is the Code of Civil Procedure, the Evidence Act, and the Indian Penal Code, more so here the evidence. If you look at the reasoning that has been given by the Supreme Court, it has been very direct. They are saying that none of the witnesses could directly identify the accused one. The constables who arrested the accused were never examined. Now that itself, the first and the second one itself is enough for me to acquit the accused, because if the constables who arrested, they themselves have not been examined, that means they have not been given a chance to be cross-examined by the defense. So if they don't examine, now if there is public prosecutor on one side which is on behalf of the state. And on the other side, there is a defendant lawyer who has been appointed by the court because they did not have the means to appoint a lawyer, the guilty or the accused, should I say. That means there could have been a possible arrangement between the two, that, some sort of a compromise arrived at, that you do not present the case properly, as you rightly pointed out, Reha, in that question when you asked the parents, do you think that the public prosecutor didn't do a sufficient job? These things happen day in, day out. I'm not saying that it has happened in this case because I was not there to witness how the whole thing went on. But imagine the Chief Justice of India, Bela Trivedi, who's a woman herself, and Ravindra Bhat. So these are three judges who have taken a viewpoint after examining the case through and through. They have come to a conclusion that there is not enough evidence to point guilt towards the accused, and that the lower courts should not be swayed by media attention or anything or external issues and just go by the evidence. And looking at the screen, that the points that you proved, or rather that you showed to me, that on the basis of which the lower courts gave the advice and gave the judgment on which the Delhi High Court confirmed it, it seems to me that the lower courts have gone by circumstantial evidence, which is absolutely fine. There's no problem about that. But now when the Supreme Court comes out with this, it's a tad too difficult for the lower courts or for any lawyer to say that all these things which are glaring evidence lapses, you call it lapses of investigation, you call lapses of trial. Even 2G scam, I mean, what happened? You've seen that.
Absolutely, and they are not conclusive, and that exactly is the big argument that, of course, was put forth. I'll just come back to you. Charu, you've been with the family members, and the fact that you've seen this entire trial proceed from the trial court to the Delhi High Court and now the apex court of the country. What the parents were claiming, do you see that, was it really true? Because do you see that there was actually that kind of a communication that should have happened when it comes to the public prosecutor was not there, and because of which these lapses that Swapnil also is talking about were very, very glaring, which is what was presented in the apex court as well? Charu, I think you're on mute. If you can unmute yourself. Charu, we are not able to hear you. All right, there's some audio issue with Charu's link. We'll get that fixed. Yogita, let me come to you. I'll ask you the same question. From the observations that have been made in the lower courts to what has happened in the apex court on Monday, how do you see things panned out and spiral out? What was going in the favor of the family members clearly not so much anymore when the matter came to the Supreme Court of the country?
See, lower and high court, I'm not sure. I mean, we were very hopeful that, of course, I was watching it from outside, but I was not part of the trial, and this is that. But in Supreme Court, each and every hearing have been there with Charu, and I mean, we were really shocked with this judgment. We were really, okay, at least we were expecting it will turn to life imprisonment, because there were no arguments as such on investigation. Charu will tell you better legally, but there was no as such, there was no doubt about the investigation much as it has come out.
So do you think it was taken for granted, and because of which probably those arguments were not well presented? And don't you think, and do you think also, to add to this question, the apex court could probably have reduced the sentence rather than acquittal?
Absolutely, they would have. At least they could have gone for re-investigation, or as they could have called the right people for whatever the lapses were. They could have asked for reopening of these lapses, or they have hardly given time to this case. Trust me on that. I've been to each and every hearing of Nirbhaya in Supreme Court. I've been to each and every hearing of this particular case. I have seen huge difference. There was a very, very ample hearing given to Nirbhaya case. In this case, hardly 10% of that time has been given. Even there, lapses on investigation were discussed, like called records were not matching the location, and all those things were discussed as such. But here it discussed maybe in 2-3 hearings. So I think it is very unfair, for them to just let them free or set them free.
So Charu, I hope you can hear me now. Are you able to hear me, Charu?
Yes, sorry, actually my voice was on mute that time. I'll answer your question. I think that the public prosecutor at the sessions must have presented the case well enough that the judge was convinced that there was enough evidence on record to prove a case beyond reasonable doubt against these three. And that's why a punishment of capital punishment was given, death was given. And when the matter goes to the High Court, because the death reference has to be done by the High Court, somehow we have a system where it's not enough if the Sessions gives it. So the High Court has upheld it. So two courts have gone through the evidence thoroughly. And let me tell you, in the Sessions, when the trial is done, the judge also sees the demeanor of the witnesses, how they're behaving, are they truthful, are they talking, everything. It's not that just some blandly typing of the whatever the testimony they're saying. Otherwise, they could have given evidence on affidavit, but they see the demeanor. And now when the matter comes, this is a fast-track court. Remember, I want you to highlight this case. This is a fast-track court case, 2000 to 2014. Sessions and High Court gave the decision. Matter comes to Supreme Court. Fast-track court case comes to Supreme Court, and it takes 7 years.
Yes.
And then on 7th April, the matter was reserved for judgment. 6.5, 7 months. On Friday, I mentioned the matter. Friday, I had to mention the matter to the Chief Justice that it's going to be his last day. So this judgment is still not pronounced. So on Monday, they come out with this absolutely shocking judgment. And as far as the prosecution, what you're saying, you see, I understand the parents' anguish. Even I'm equally shocked. But the prosecution has presented the case.
All right.
Well,
that's
why this.
All right. Some problem with Charu's link again. So, Swapnil, coming back to you. When it comes to capital punishment cases, there is data to suggest that out of, let's say, about 49 or 42 of those, just one is upheld. That is the number of fallouts that we are talking about. And also how the lower courts are sort of trigger happy to give and be more than ready to give capital punishments. Don't you think it is not fair? It's absolutely unfair on the part of the family members of the victim who are actually looking up to the judiciary for this kind of a justice?
Well, yes. First of all, I completely sympathize with the victim's family. And it is true that the trial court and the high courts are trigger happy because they believe that death penalty is there. So it's a rarest of rare case. It was brutal rape, and that's how we should award it. Now, the Supreme Court has a different viewpoint on it. First of all, I don't think it saw the crime the way it rather didn't see a crime at all. Or rather, even if it saw, it did not see enough evidence supporting the crime. Now, my advice will be on two aspects. The first is, I think, to say that it took 7 years for the Supreme Court. The answer is no. From what I understand is that the appeal was filed to the Supreme Court in 2019. So then obviously 6 to 7 months for a judgment to come. That's rather strange. Now that is something which definitely brooks my attention. And I would definitely go into a review petition as far as this aspect is concerned. I would not disappoint the family members. I strongly suggest that they should go for a review petition. That is one. Two, that they should go with all the findings of the lower courts and try to point out that those findings also merit a consideration. Even if there are these two glaring lapses, which I just pointed out in my first comment to you, I think there is enough substantial circumstantial evidence to point fingers towards the accused, and that they need to go. All of these, threats that you gave that we'll cut you out, and the moment you come out of the court, all of these doesn't apply. What applies is what matters is, as one of my panelists pointed out, the behavior before the court, and they could be absolutely straightforward, nice, innocent guys the way they are behaving. Ultimately, it's the evidence that has been presented. Griha, let me tell you one thing. When it comes to the Supreme Court, or for that matter, any court, for that matter, at the highest level, generally, an investigation is not looked into unless, of course, here the defense would have tried extremely hard to reopen every aspect of the investigation done by the public prosecutor and the police and pointed out major holes. To say that the investigation was never argued itself is a fallacy, because unless you argue on the lapses of the investigation, how do you get that, the judgment completely reversed? So the investigation must have been literally punctured through and through by the defense counsel. And the court must have stood convinced that, yes, there are enough punctures to say that the case is not
But was it good enough to acquit them? Was it good enough to acquit them still?
Yes. Yes, I completely, that is where I would want to go into a review petition and literally hammer it down, saying that it seems that the court has not given enough attention to this case. the way it needed to be given, because 2-3 hearings, if that is the case, then I think it's a tad too short. Okay. Even if those are full day hearings, I think it's a tad too short.
But
for this kind of a case.
Charu, do you have any hope with the review for petition? Because again, data suggests 95% of those filed before the apex court are dismissed.
No, I have absolute full faith. Let me tell you, I'm very confident, hopeful, and I believe that the review petition will definitely be admitted, because that's why we're taking our time. Otherwise, we could have rushed 2 days after the judgment. We have 1 day holiday, Gurpurab, and the next day we could have gone for a review, but we didn't want to do anything in a hurry. As my friend on the panel said, that we are going through all the evidences to show how this judgment is flawed. And again, everyone is being misled by this first statement that the test identification parade was not held. Let me tell you, witness, that girl has said it was dark. I did not see anything properly. I just saw the red indica come and they grabbed that girl and abducted her. Is it not futile to hold a TIP and put 4 people in front of you and say, Inam, Inam, or guess one? I mean, so that's what I'm trying to say.
So, Yogita, you have dealt with so many of such cases. What has happened in Kiran's case? Do you see that there are strong loopholes in the criminal justice system of the country that also needs to be looked at? And then, what happens to the justice call for Kiran?
I don't know in this particular case. I can say that it is justice delayed and justice denied both. Unfortunately, we have to work a lot on reforms. Charu was with me a while ago and we were discussing overall. It's not the only case. Now this has come out to the limelight. We know, how it has been treated. And the other person also was saying that enough time which was supposed to be given by the Supreme Court to such kind of a case, which really needs a lot of attention, was not given. So any which ways, everybody has failed this victim's family and this girl. Everyone. Even if you are saying investigation is botched up, you do something about it. You need to put some agency on it. If you were not happy, you cannot just make one statement in 10 seconds as Charu was there in that particular courtroom, and by that woman, just that they are set free. I mean, you need to understand the sentiments of the victim family also. I mean, the judgment came much later. What kind of an example are you setting in? They are out since yesterday, 2 of them. Do you think they'll not be mingling with the
Absolutely, and that's a larger question that also needs to be answered. However, that's all the time that I had. I'd like to thank all my guests, but not without this important question that has been queued by Yogita, of course. What happens to the safety of the family members of the victim in this case? Because here, in this case, the 3 accused who have been let off by the apex court of the country also were history sheeters, and they have known to actually threaten the family members of the victim. What happens to their safety is also the larger question that needs to be looked at. And wasn't it fair had the sentence not been reduced rather than acquitting the accused altogether is again the big question. We'll leave it at that. We are shifting our focus to some breaking news that we are now getting on the broadcast. As India's Foreign Minister S. Jaishankar has addressed the Hindustan Times Leadership Summit today, and while speaking about democracy, the Foreign Minister made a subtle remark on the West and the media. He said, and I quote him here, when democracy gives results that do not suit an elite in some part of the world, we start attaching adjectives and caveats to it.
We speak today about democracy, but I point out to you, when democracy gives results which sometimes does not suit an elite in some part of the world, immediately you start attaching adjectives and caveats. No, this is completely ideological.
An important statement that has been made by Foreign Minister S. Jaishankar. Remember, he was addressing the Hindustan Times Leadership Summit, and this was when he was speaking about democracy and the larger perspective of democracy. Now, he went on to make this remark when it comes to democracy in the Western world and also the media. He went on to say that when democracy gives results that do not suit an elite in some part of the world, then is when there are adjectives and caveats that start to be associated with it. An important remark that has been made, and this is of course a subtle cue and a stinging criticism at what can be termed as democracy in the West, and how media also is responsible for twisting what are the facts. This is a statement that has been made by the Foreign Minister S. Jaishankar. We will see what is the kind of reactions that actually is brought about by these statements that have been mentioned by Mr. Jaishankar, talking about the Western elitism and how media is also partisan to the views and shaping those views and also twisting them if at all it's not suiting the Western elite. This is what the Foreign Minister had gone on to say. We'll leave it at that. And with that, I am slipping into a very short break. My colleague Poonam is joining you on the other side with Plain Speak.
Good evening, you're watching Plain Speak on CNN News 18 with me, Poonam Burde. The Assam government has ordered public madrasas in the state to share full details about their institutions. The number of teachers, students, the locations of the teachers, where they come from, their salaries and the land on which they operate. All of this will be uploaded on the government portal. Now, the government has also mandated police verification for all the teachers that are willing to teach or are already teaching in these madrasas, all of which are privately owned. Now, there are over 1,000 privately run madrasas in the state of Assam that report to 5 separate boards. All of them will now have to furnish these details to the state government, upload them on the government website for everyone to see by the 1st of December, which is less than a month away. Now, remember, the Assam government has been cracking down on madrasas. It started with state-run madrasas sometime after the Hemanta Biswa Sarma government came into power. The state-run madrasas ceased to exist because the state refused to fund schools for religious teachings. That decision was also upheld by the highest court of this country. Add to that the demolitions of at least 3 madrasas that were held by the state government in the month of August, all of which because of their alleged links to terror. Now, this latest move coming in. This is not seen merely as a clampdown though, because there is a conspiracy is what many are alleging. Religious institutions cannot be meddled with, is their argument. But does that argument hold water, especially when terror linkages, like in the case of Assam, are under the scanner? Now, before we open this up for debate and I ask those questions to my panelists, let me break down for you the reasons of why this audit is happening in the state of Assam. The number one reason for this audit or for this monitoring of privately run madrasas is that many of these madrasas, teachers of which have alleged terror links, were arrested in the last 1 year itself. Reason number 2 of why the government is doing this is because the lens on these madrasas and link with fundamental organizations and fundamentalists. Another big reason of why the state government is doing this is there were at least 3 madrasas that were found to be jihadi hubs, which were demolished by the state government, and 1 was demolished by locals in one of the regions of Assam. Reason number 4 is that there are several foreign nationals that enter India via these madrasas where they teach. That's something that the government wants to crack down on, or at least have a monitoring policy for. And reason number 5 of why the Assam government is doing this is because they believe that there are jihadi acts that actually take place under the garb of these religious lessons. That is why the government wants a monitoring policy in place. This move, of course, has split opinions down the middle. There are people who say that this crackdown is necessary because many of them promote radicalization and anti-national activity in the name of religious teachings. The counter-argument to that is that these are philosophies of several Deobandis and others that are being twisted. Many are also seeing this move as a bid to improve and legalize funding.